Hi everyone, my name is Wayne Pollock. I am an attorney that helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion to help those clients resolve their cases favorably and help those attorneys build their practices. I wanted to talk to you in this video about one of the defamation traps that attorneys fall into on a frequent basis without even knowing it. I'm talking about attorneys sending copies of complaints that they filed and signed to reporters. It's a common practice. Attorneys often do that when they want to provide information about the complaint or the lawsuit to a reporter. But most attorneys have no idea that what they're doing is actually setting themselves up as a matter of law to be liable for defamation. Here's the way that works. When you and I and other attorneys file complaints in court or make defamatory allegations in other documents, we are generally covered against defamation by the litigation privilege that tells us that as long as we make these defamatory allegations or defamatory statements in documents that are both material and pertinent to a case and that also naturally arise within a legal dispute, then we're fine and we're covered by this privilege because we as attorneys need to be able to tell our clients' stories unencumbered and freely without worrying about defamation. But most courts say as soon as attorneys make those statements outside of court, including taking copies of a complaint they've signed and sending it to a reporter, yes, even the court-stamped as filed copy, courts say at that point attorneys are making statements to the press that are neither material and pertinent to a case and that do not naturally arise out of a case or a legal dispute. I, of course, disagree with that, but that's the case law in many jurisdictions, including Pennsylvania. There's a Pennsylvania Supreme Court case that says that attorneys, as a matter of law, can be liable for defamation when they send a copy of a complaint they filed and signed to a reporter because essentially the attorneys are republishing a defamatory statement. So here's how you avoid that problem. You don't send a copy of a complaint to a reporter. You send them to the docket, you give them the docket number and the document number. They know how to pull documents off Pacer. They know how to pull state court documents. That is a way for you as an attorney to avoid being liable as a matter of law for defamation when you give a copy of a complaint to a reporter. Now, in case you're curious, there's a qualified privilege that's available to attorneys when attorneys accurately recite and quote the contents of a public record or a court document, as long as they're not doing so with malice or they know that the document that they are quoting from actually contains defamatory allegations. Then attorneys can use that qualified privilege as a factual defense. But the issue is that that's a factual defense. And if you ever got sued by the other party for filing a complaint and then sending it to a reporter and thus defaming that other party, it's going to survive a motion to dismiss. So my advice to attorneys is do not send copies of a complaint directly to a reporter. Either have someone else do it or send the reporter to the docket. They'll pull the documents, they'll pull whatever else they need to pull, and you won't have to worry about this defamation trap that sneaks up on attorneys and that most attorneys have no idea even exists.